And that also is a potential inducement. So if the threat of a deal away was not enough, sponsors would go to lenders and say, look, I can improve your position in my capital structure and potentially improve your recovery if things don't go well in a bankruptcy. If we do a transaction where we amend the credit agreement, you can up-tier your debt, prime the other lenders, put in new money, and it's all perfectly legal under the documents because they're super loose. And that was liability management 1.0. The initial deals, think Serta, think Mitel, they were deals where a subset of lenders and the sponsor did a transaction together, often at the expense of minority lenders. And that was, for a time great, but that spawned litigation, which we'll talk about in a moment. What eventually happened after that was a recognition that the 1.0 deals where you're leaving out substantial lenders can induce litigation. Sometimes they don't cure the underlying problem. Sometimes you want consensus to extend maturities, but you can't get to 51%. And so what evolved is what we call liability management 2.0, where it's the same setup where the sponsor approaches lenders, you do a deal with a subset of lenders, but you offer a deal to the remaining lenders, but not as good of a deal as the original deal to the steerco or the inside group of lenders. And so when faced with the choice of potentially litigating, which may not be the best option for minority lenders, or doing a slightly worse deal but participating in a transaction where the minority lenders are not left at the bottom of the capital structure, we saw a lot of deals, this is 2 or 3 years ago, where the minority lenders were dragged into a deal. And so you got very high uptake in LMEs, that's LME 2.0. And then I think we're in LME 3.0 now, which we'll talk about, which is a little more consensual, where I think the market has reacted to the first 2 generations of liability management. We see cooperation agreements, we see much tighter documents, Serta protection, J-Crew protection, protections that are built in not merely when there are workout amendments, but new issue that make it a lot harder for sponsors to do this types of liability management 1.0 deals. So we're seeing an evolution in the market. Participants are more sophisticated, but we're still seeing LMEs, and a lot of them. And the litigation has abated somewhat, but it hasn't abated fully.
Osh, what do you have to add to that from a banker's perspective?
Yeah, I think what's interesting as part of the most recent iteration of LME is while there are more pro-rata deals and there are more cooperation agreements, I think as a result what you're seeing is more proliferation of the potential of a deal away to induce the existing creditors to try to provide the asks that you're looking for, whether it's maturity extension or discount capture or liquidity increases. I think we're all working on deals where I think over time you will see folks get creative and still find ways to pit lenders against each other, whether that means they go to a subset of the lenders early instead of waiting for a cooperation agreement to come about. But I think it's an evolving field. I think the documents are still evolving. I think what's probably most interesting that we see today is, despite the fact that there were previously loose documents that were taken advantage of, and despite the fact that there's still new protections being inserted on a regular basis, there's still quite a bit of flexibility in those documents. And there are still ways for sponsors and companies to utilize those assets that are in their credit agreements to their advantage. I will also say, I think what we're seeing more and more as of late is not only sponsors utilizing these documents, but also public companies more frequently utilizing them as well. And I think that would be a trend that will continue for a while as public companies that are typically higher rated have more open documents will realize that this is something that they should be considering.
Explain, you mentioned, and Adam mentioned it also, the concept of the deal away. Explain that for the deal away is a
Totally.
foil, so to speak, to a regular deal with audience.
Yeah, I would say, look, I think what you can get from, maybe the way to start off is the distinction between what a deal away is versus what your existing creditors can give you. What your existing creditors can give you, under the right circumstances, is a combination of maturity extension, new money / liquidity, and discount capture to help you deleverage. What a deal away means is that you would go to a third party, you would utilize some of the investment baskets that Adam is getting at, maybe move assets into a non-guarantor restricted subsidiary or into an unrestricted subsidiary, and you would ask the third party to provide new money to lend against that site where there are now assets. So while the third party can't provide you with maturity extension or discount capture, they can provide you with new money. And that new money that effectively primes existing lenders is basically what causes those existing lenders to say, you know what, I know we were being aggressive, but let us come to work with you as part of a transaction where we can provide more than we were offering before. I don't know if you have anything more to there.
Well, question there for both of you. Is there a deal away, is it a bluff, or does it actually happen?
It used to be a bluff. I mean, 9 times out of 10, when we assessed the deal away risk, we looked at the legal documentation, we looked at the business to see how realistic it was for a business to be severed among subsidiaries and have capital raised. And you know, as recently as a few years ago, it was very unlikely. Intellectual property was the only exception where, and that happened in J. Crew, where intellectual property very easily severable and could be moved into an IP co, and then you could raise capital against that. But barring that, it was rare that you would find a susceptible structure to a deal away. That's changing now. What we're seeing more and more are devoted pockets of capital, special situations funds, where their mandate is to invest in bespoke, esoteric products and investment opportunities. And so the deal away market, so to speak, is actually becoming kind of robust. And we're seeing competitive pricing when it comes to a deal away versus, you know, the deal that lenders can offer. I still think incumbent lenders have a leg up, but it's becoming more competitive.
Okay, question for Emil. There's obviously been, starting 5 or 6 years ago, a lot of litigation over the LMEs, and you personally been front and center in several of these cases. How has the results of that litigation, where they've gotten final decisions or settled, impacted the various market participants in just deciding how to structure the LME transaction?
Thanks, Paul, and hi, everybody. So I think the answer to that is somewhat nuanced in that there have been theories that have been advanced really from the beginning of LME litigation, at least the last few years of LME litigation, that if those theories had gotten traction, I think would have had very significant implications for LME as a field. And in particular, what I'm referring to are theories that equity owners, namely equity sponsors or directors appointed by equity sponsors, could have liability for whatever harm is allegedly caused to lenders who are not in the deal. Those kinds of theories, if they got traction, I think would have had very significant implications. They really have not gotten traction. And what I mean by that is in nearly all of these cases, CERTA, board writers, Trimark, Mitel, there have been claims of tortious interference with contract against the equity sponsor or other third parties. And those claims have, I think, uniformly been rejected, often on a motion to dismiss on the basis that an equity sponsor has a pre-existing economic interest, such that even if there was a breach, the sponsor is protected under New York law for taking actions to protect its equity stake in the company. Likewise, there have been rumblings of fiduciary claims against directors in connection with LME transactions, but they really haven't gotten traction either. Set aside situations where the sponsor is on both sides of the transaction, because the sponsor might have a debt fund that is part of the transaction. Set aside those situations which present, I think, their own set of issues. In kind of regular transactions where the sponsor is just on the equity side, the claims against directors really haven't gotten off the ground on the basis that under basic Delaware law, really, even in an insolvent situation, under the Gawala case going back almost 20 years now, Delaware directors, their duty to the company includes a duty to take into account creditor interests. It's really creditors as a whole. I mean, Delaware law does not recognize fiduciary duties to particular creditors, such that if you have a situation where lenders are pitted against each other, but the transaction in the business judgment of the board benefits the company, that's likely not going to form a basis for a fiduciary claim under Delaware law. So the punchline of all that is that there really has not been successful litigation trying to hold non-contract parties liable for any harm resulting from LME. And as a result, there has not been kind of a real deterrent to LME based on that kind of theory. In contrast, some of the decisions that have come out of the contractual claims, and we can get into more of this, I'll stop for now, but some of the decisions that have at least suggested that new money put into LME deals could be at risk, like in Cora, like CERTA, certainly have had an effect. And to Adam's point, I think are one of the various factors that have led to this transition from what was called 1.0 to 2.0, which tends to be less winner take all and somewhat more cooperative.
Can you extrapolate where we're going from here?
Sure. I mean, I think on the litigation front, there's a number of, I'll call them legacy cases that are still outstanding, including CERTA, including in Cora, which is going through the appellate process. So part of where we go from here, I think, is going to depend on the result of those decisions. But I think the main takeaway in terms of where we're going from here is that in nearly all these cases, while there's been very substantial debate and a number of successful appeals as to what the contractual language means, I think we are in a world where that is the main issue. Do the transactions comply with the four corners of the document, as opposed to a whole bunch of other theories that at the earlier stage of LME litigation had been put forward, whether it's implied covenant of good faith and fair dealing, tortious interference, breach of fiduciary duty. I think one thing that's in common in these cases, or there's a lot of divergence, but one thing that's in common is that in general, judges have really ended up focusing on the specific language of these agreements rather than relying on kind of overriding equitable principles or conduct-based claims.
One thing to layer on is what we've learned in the last few years is there are, leaving aside the substance, the merits, there are substantial practical challenges to bringing about litigation in the LME space. For minority lenders who are left out, this is not a cost-free endeavor. It's costly, it can take time. Even when they win, sometimes it's a pyrrhic victory because the company landed in bankruptcy, like Mitel is a good example, of a company that, it was a 3-year-long litigation. It worked its way up to the appellate division in New York. The appellate division upheld the transaction, overturned a lower court decision, and then 3 months later, the company filed for bankruptcy, and the left-out lenders ended up getting nothing. And so it's hard in that respect. There's another element here, too, which is a lot of the players in the BSL space are repeat players. And so if I'm a small lender or CLO manager and I feel aggrieved and want to sue, that might have repercussions down the road. If I sue the sponsor may be disinclined to let me into future deals, and so that worsens my ability to put capital to work. And also, if I sue other lenders on like an aiding and abetting theory or some other theory, those lenders are not going to be the ones who let me into the in-group on the next liability management transaction. So those are just a couple of considerations that we're seeing in the market play out in terms of deterring people from litigating.
We talk about 1.0, 2.0, now possibly 3.0. What are the trends Adam, Josh, you two on this one, you see as we go into 2026?
Yeah, I mentioned these earlier. I think what we're seeing more and more is, a couple of things. First, there was a significant maturity wall in 25 and 26. And so we had significant LME inventory that we addressed in 23 and to a lesser extent in 24. And so in 2025, the LME activity, at least from our vantage point, softened and weakened. And so there was a bit of a dip. There were fewer drag-along liability management 2.0 deals, more what we call 3.0 deals, which are really regular way amend and extend with a mix of carrots and sticks to induce people to participate. I think that 3.0 trend was driven by the proliferation of co-op agreements, slightly tighter documents, and candidly sponsor fatigue with some of the litigation that occurred out of LME 1.0. I think we're going to see a lot of that play out again in 2026, but we have a big maturity wall coming out ahead of us in 2028 and 2029. And so those are maturities that are going to have to be addressed. And what we're seeing is a window of opportunity right now, end of 25, early 26, where if the sponsors don't use the deal away threat and approach their lenders to do something about those maturities, the window of opportunity to use the value of the flexibility in their documents is going to close. And before they know it, we're going to be at the end of 26 or 2027, we're only a year away from the maturity, and then the ability of the sponsor to lever lenders is significantly weakened, and lenders, have more leverage when the maturity is closer at hand.
Yeah, well, I agree completely with that. I think one other trend that we're starting to see more and more of is the private credit trend. And in, call it 22, 23, 24, you saw more and more of the sponsor-backed acquisitions being funded with private credit instead of BSL, broadly syndicated loans. In fact, it may have crossed over in terms of more private credit than broadly syndicated loans. What we haven't yet seen is how a private credit LME may play out if it were to ever occur. Many of those acquisitions occurred, LBOs occurred in the call it 23, 24 timeframe, typically with call it 6, 7, 8 year debt. So it's still a little bit early in the vintage, I would say, to figure out where and when you're going to see many restructurings. But I think that will be more of a trend going forward, is how will that play out and what will serve as a bellwether for distress in the private credit space.
I'll just add one thing, which is that I think now that we're getting toward the end of 2025, people forget that a number of the most prominent 1.0 transactions occurred in an extreme situation, which was essentially COVID and its aftermath. I think that's true of CERTA, Cora. If you go down Trimark, if you go to right, so you go down the list of some of the more winner-take-all litigious LME transactions. They happened in a highly disruptive, unprecedented market situation. And there's this trend which my colleagues have pointed to of more cooperative, less litigious LME transactions. I think one big question is what happens next time there's a major market disruption. It's a lot easier to do version 3.0 or version 2.0 in a context where interest rates are stable. There aren't extreme liquidity challenges. There's predictability. But if we get, it's not going to be COVID, I expect, but if we get to some new market shock, are we going to be back to, if not 1.0, 1.5, something that's more aggressive?
Yeah, I agree with that. I also think the big open question is, in the next market shock, how are we going to deal with the private credit situation? Are the LME tactics that we've seen in the BSL market, which I think have been pretty effective when you had a few years ago, it's changed now, relatively less sophisticated, smaller CLO managers who are not paying as close attention to small positions where the situation was bordering on distress. In private credit space, you have that has proliferated, like Ash said, and you're going to see private credit debt eclipse BSL loans in terms of volume. But in those loans, they're called club deals for a reason. You have far fewer lenders, usually between 5 and 10, maybe fewer, maybe a little more. And all of those lenders have strong relationships, not only with each other, but with the sponsor. And so when you get distress in those situations, and when the sponsor doesn't want to turn over the keys, lately we've been seeing private credit workouts where the sponsor just walks away peacefully and the lenders take over. If the sponsor doesn't want to do that because there's some shock and the sponsor believes there will be a rebound to their business in the future, how is that going to play out? And I think that's a great unknown. And the docs, by the way, are pretty loose in private credit.
I mean, one of the reasons why I think if there's another market shock, we are going to potentially see more aggressive deals again, 1.5 or the like, is that, and then we're talking to a restructuring Chapter 11 audience, is that, I mean, what LME, at least one of the things that LME transactions are intended to do is you get some of the things that one often associates with the bankruptcy process, like the ability to get new financing, priming financing, without the extremely high cost of a bankruptcy case and the other externalities and difficulties of a bankruptcy case. So, I mean, the basic theory behind why during the COVID and post-COVID period, companies were using LME despite on some of the 1.0 transactions, litigation risk and disruption is because they were looking at the alternatives of a Chapter 11 with all of its costs versus an out-of-court restructure that would have friction and potentially litigation, but the possibility at least of not having to end up going through the Chapter 11 process, and in some cases it worked, in some cases it didn't.
Yeah, but didn't those 1.0, 1.5s, where they did fail, okay, and I totally agree, they were put together, hey, we want to avoid the high cost or minimize the risk of the high cost of an in-court process. When they did fail, you basically had Chapter 11 cases, in a few instances, where it was just a cloud on the case, right? So was the resulting cost of the Chapter 11 actually much greater because you had to unwind that litigation, you had to put the Chapter 11 case on hold while the rights of the, we'll call it the winning creditor group versus the loser creditor group were litigated, again, oftentimes in Southern Texas. Seemed to me, at least in a few instances, that was a very, very high cost.
No, I agree. I think of it in sort of two poles. One pole is you have unresolved LME litigation and the company files for bankruptcy. That's in Cora, that can exact a very high cost, no question. There's another pole, however, which is when you do one of these LME transactions, you've tightened the documents so much, you've created such a detailed and well-drafted intercreditor agreement that parties, that pre-legislates a lot of the disputes that might arise in Chapter 11, and it actually makes it a lot more efficient if the company were to file for Chapter 11. We saw that, I think, in two instances. We were involved in the Diebold Nixdorf bankruptcy, which filed down here in Texas. We were also involved in the Wheelpros bankruptcy, which filed in Delaware. Both of those were failed LMEs, but they were also both pre-packs. And I think it would have been more contentious with the first lien, second lien, in some cases third lien structure, without the rights that you had negotiated in the LME documents. If you hadn't had those, there might have been a food fight over valuation, dip, other issues that come up in Chapter 11s. You take that off the table a lot of the time when you work on these LME deals.
But those cases they were as a result of the kind of the general LME, right?
They were. That's fair.
Yeah, because it seems to me that's an argument, or at least a very good argument for 2.0, 3.0, is that you really are in that situation, unlike, kind of the winner-takes-all approach of the early LMEs, is, you guys outlined in connection with the COVID and everything that came from that. Now, we really are seeing stuff where, yes, we're going to do this. We're going to get the benefits, whether it's, extended maturities, PIK interest, additional liquidity, all the, hopefully the benefits you're getting from doing the transaction. But because it's less coercive, more democratic, that when you do go to the chapter, it's exactly what you're talking about. It's a prepackaged case. So you are really, at the end of the day, doing that, giving the company a shot, a very good shot, hopefully, staying outside of court. But if you have to go to court, it's not going to have the burden of a in-cora type litigation clouding the case for the first 9 months.
No, I agree with that. And I think one just point to make is that when the parties are negotiating the transaction, the LME transaction, the argument that you articulated in terms of, well, look at it in Cora where you had a huge cloud over the case and tremendous cost. in ex ante, it's hard to see that being the deciding factor when the deal is first made, because whether rightly or wrongly, the perception of the parties, the equity owner is likely, I think this company still has a shot, and I want to preserve whatever equity value or option value I have, for the lenders, whether it's a winner take all or a more time or gentle, I like that version. The way you put it, I mean, their perspective is going to be, there are various off ramps to a long, contentious, expensive Chapter 11. One off ramp is, you won't get challenged. There are LME transactions that, for various reasons, don't get challenged because they actually are good transactions that benefit everybody. Another off ramp is there'll be a challenge, but we'll win it quickly, which happens also. A third off ramp is there'll be a challenge and it'll be settled pre-bankruptcy. Like there are examples of that, like Trimark. Another off ramp is there'll be a challenge that the company will perform better. Like in a case called Intralot, there was a litigation brought, but not that long it became clear that the transaction was helpful and the debt would get refinanced. So I think if the decision makers at the time when they do an LME transaction, it's hard to get the perspective of, there's going to be a long, ugly bankruptcy to actually affect the decision making.
Well, one of the, certainly when you do the LMEs, and you had mentioned it just a second ago, is the preservation of option value for the sponsor. And again, we're thinking, where most LMEs play out, which is in the private equity market. You get, again, we talk about the extensions almost always, additional liquidity, PIK interest, these sort of things to help liquidity. I think one of the arguments when I talk to speak with you and other bankers and just people, is they really don't, are they just buying time, but they don't really fix the business? Okay, that's the, I mean, I guess in theory it provides more time to do the fix. But of all these, and maybe this is kind of a related question, which is, how many of these LMEs are ultimately successful in the sense that they either lead to improved business performance and ultimately, I would assume, refinancing or equity solution?
I mean, I think we'll see what the result is of some of the 2.0s and 3.0s that have occurred in the last couple of years, so there's still quite a bit of time until those maturities play out. But look, I think that's right, Paul. There's value here. Right? The value is a combination of maturity and liquidity runway. That's the time value of your option. There's the reduction in debt at times when you're capturing discount, and that is the reduction of the call strike price. So yeah, there's value here, but I think we'll have to see how it all plays out, given the last 2 to 3 years have been where you've seen the bulk of the LMEs, and most of those maturity extensions have gone through 27, 28, 29. So we've got a little bit of time to see how they play out.
One of the things, Adam, you mentioned, and for the audience today, was the use of co-op agreements, and at least my appreciation, or with the cooperation, short hand co-op agreements, is that in 1.0 you really didn't have co-op agreements. It's really a creature of the evolution. And I'd love for you to kind of let people know really what is a co-op agreement. Related question, obviously, is there's been some, noise out in the press that said, hey, these co-op agreements are being signed up well in advance of any sort of dark clouds and maturity. I'm just interested in getting y'all's thoughts on those. What is a co-op agreement? When are people putting them in place? Why are they putting them in place?
Yeah.
How do those play in that?
I can go on and on about that. Just very at bottom, the co-op agreement is an agreement among the lenders in a particular credit facility, generally not to agree to a transaction with the company unless it's A, approved by the majority of the lenders of the co-op, and B, offered ratably to everybody on generally equal terms, subject to various exceptions. If you have a supermajority of lenders, 70%, 80%, 90% sign up the co-op agreement, it's very hard to do a 1.0 deal. and it lets lenders sort of sleep well at night. Sponsors and companies generally disfavor co-op agreements because it limits their ability to play creditors off of each other. There's been accusations that co-op agreements constitute antitrust violations. And so, in a nutshell, that's cooperation agreement. There's various flavors to cooperation agreements. Some are open, some are closed. There's debates over, duration of co-op agreement, how to improve transactions drafted, that sort of thing. But that's what a co-op agreement is in a nutshell. I think our house view at Davis Polk is co-op agreements have a place, but they're not a one-size-fits-all. I think co-op agreements are useful when you sense that sponsor might be aggressive. I think where we question the usefulness of co-op agreements is just what you said, Paul, where it feels like co-op agreements are being proposed so early, practically a new issue, where there's nothing happening, and in some respects it's a way for lenders to feel like they're grafting onto the credit agreement a set of rules. And co-op agreements have also evolved where now you have stratification within the co-op agreement, whereas originally it was all approved transaction has to be offered pro rata. Now it's approved transaction has to be offered pro rata, except for a steering committee, which can constitute the largest ex-lender. And so you're creating exceptions that sort of swallow the purpose of a co-op agreement. I think the market is shifting toward co-op agreements because there's a false sense of comfort that, especially smaller minority lenders, find in co-op agreements. It's easier for them to justify their remaining in the credit and not selling out if they're part of your co-op agreement.
The concept of not being left behind.
Correct.
1.0, if you were a minority lender, oftentimes you didn't know that until after the transaction closed.
Yeah, just one other point. I mean, co-op agreements has been one response to the 1.0 transactions. I think just to state something that probably a lot of people know is that the 1.0 transactions has also led to changes in loan agreements themselves. So in new financing documents, people have what are known as SERTA blockers or J-Crew blockers. J-Crew goes to people pre-1.0. Incora blockers. So, and I guess there's endless resourcefulness, so maybe there'll be new approaches, but it's a very dynamic market. It's not as if the same transactions that fall within the 1.0 category with these up tiers can't be addressed in contracts. They can be, to the extent they're not addressed in contracts. One could argue that those underlying initial 1.0 transactions caught people off guard, but it's much harder to argue that if you have a contract that's being entered tomorrow that explicitly addresses the sacred rights either allow for an up tiering or they don't. That's parties negotiated in advance to address the issue that arguably 5 years ago caught people off guard.
And to be clear in the co-op agreements, no one's litigated those rights as far as people breaking and running, or have they been?
Not yet. There was one litigation filed a couple weeks ago in the Selecta.
Okay.
That's a little bit of an anomaly, but generally speaking, they're not litigated, at least not among lenders.
Well, I think we're at a time. Any questions from the audience? Okay. Well, thank you, and we appreciate your time.